Good morning. The Crime, Terrorism, Homeland Security, and Investigation Subcommittee will come to order. Without objection, the Chair is authorized to declare recesses of the subcommittee at any time, and we welcome our witnesses today. I'll begin by recognizing myself for an opening statement. Welcome, Administrator Lenhart, to your first appearance before the House Judiciary Committee since June of 2012. We thank you for your service and are happy to have you here with us today. Just last week, this committee reported two bills that directly affect DEA operations. H.R. 4299 addresses concerns that I and other members have with the increasing length of time DEA has expended in recent years to schedule new controlled substances, thus delaying patient access to new therapies. Reducing these scheduling timeframes is important, but it should not be achieved by eliminating the Drug Enforcement Administration's critical role in the scheduling process. The substitute amendment I offered in markup codified a reasonable, shorter scheduling timeframe while preserving its vital role in the scheduling process. H.R. 4771 adds 25 new substances to the list of anabolic steroids in the Controlled Substances Act. In cooperation with our Democratic colleagues, the Judiciary Committee unanimously approved a substitute amendment to remove an unnecessary and largely redundant criminal penalty and streamline the civil penalties for the illicit manufacture, distribution, and dispensation of these substances. Earlier this year, this committee collaborated with our Energy and Commerce Committee colleagues on another piece of legislation, H.R. 4709, which streamlines the process for the revocation or suspension of a registration to manufacture, distribute, or dispense controlled substances. It is indisputable that our nation is facing a public health crisis due to prescription drug abuse, and we know that much of the illicit activity that diverts prescription drugs from the illegitimate supply chain happens in the United States. However, we cannot solve that problem by simply cutting off legitimate access to prescription drugs. While H.R. 4709 is not a perfect bill, and I invite DEA's additional comments to improve the bill, we must ensure that federal law punishes the bad actors who illicitly divert drugs from the supply chain while protecting legitimate law-abiding businesses. Under my leadership, this committee will continue to conduct robust oversight of the DEA to ensure that vigorous enforcement of our federal drug laws does not compromise responsible regulation of prescription drugs and patient access to life-improving or even life-saving medications. Unfortunately, vigorous enforcement of our federal drug laws has been repeatedly compromised by this administration. President Obama and Attorney General Holder have repeatedly demonstrated their disregard for the Constitution and the founding principle of separation of powers. They have circumvented the legislative process, ignored the will of Congress and the American people, and usurped the constitutional role of the legislative branch by unilaterally changing or ignoring federal laws with which we disagree. These policies have touched many areas and taken many forms, not the least of which is the frontal assault on federal drug enforcement and sentencing. Since 2009, and at the specific direction of Attorney General Eric Holder, the Justice Department has issued directives and memos with the goal of softening its enforcement of federal drug laws to a level not seen in the 40-year history of the Drug Enforcement Administration. Specifically, Attorney General and Deputy Attorney General have directed federal prosecutors to not pursue cases against certain offenders even though they violated federal law, directed federal prosecutors to selectively enforce federal financial crimes against institutions handling marijuana proceeds, directed federal prosecutors not to allege drug quantities in cases where the quantity could potentially trigger mandatory minimum sentences, directed federal prosecutors not to object to motions by defense counsel to apply lower proposed sentencing guidelines, and initiated a campaign to solicit clemency petitions from an entire class of federal drug offenders. Whether we agree on the policy is beside the point. The President has a constitutional duty to take care that the laws be faithfully executed. The Take Care Clause requires the President to enforce all constitutionally valid acts of Congress, regardless of his own administration's view of their wisdom or policy. These unilateral executive actions have put the DEA, and especially its line agents, in an impossible position. They must now choose between doing their job and obeying their boss. For example, of this Hobson's choice, we need look no further than the testimony of the witness that appears before us today. In testimony before the Senate Judiciary Committee on April 30th, 2014, Administrator Lenhart refused to support legislation to slash mandatory minimum sentences for drug trafficking offenses when she remarked, having been in law enforcement for 33 years and a Baltimore City police officer before that, I can tell you that for me and for the agents that work for DEA, mandatory minimums have been very important to our investigations. Following her testimony, it has been well documented that Ms. Lenhart was called in by the Attorney General for a one-on-one chat about her recent insubordination, end quote. Apparently, in this administration, a dedication to enforcing the law amounts to, quote, insubordination, end quote. The selective enforcement of federal law and lack of respect for the constitutional separation of powers has become a hallmark of the Obama administration. It is a source of profound concern for me and the members of this committee. Again, it is Congress's responsibility to make policy decisions about whether to address mandatory minimums and other hot-button items. It is the administration's responsibility to enforce the laws. Administrator Lenhart, I look forward to your testimony regarding the challenges facing the DEA today. And in consultation with the ranking member of the subcommittee, I ask unanimous consent to allow me to yield briefly to the gentleman from Pennsylvania who is not a member of the subcommittee but is a member of the full committee and is keenly interested in the issues before us today and who also needs to slip away to another committee. So without objection, I now recognize the gentleman from Pennsylvania, Mr. Marino, for his comments.
Thank you, Chairman, and thank you, Ranking Member. I truly appreciate this. Administrator, thank you for being here. Thank you for what the professionals at DEA do to fight the illegal distribution of narcotics. There are heroes in your agency, and I've worked with them directly. I can't overstate my respect for the DEA and its mission. My congressional colleagues, Chu, Blackburn, Welsh, and I authored a bill that will clarify the responsibilities of the legitimate prescription drug supply industry and facilitate collaboration. Our bill passed the House unanimously. Today, companion legislation will be introduced in the Senate by Senators Hatch and Whitehouse. Let me say this with the utmost respect. Congress is sending the DEA a message. You should take a serious look at your regulatory culture and seek collaboration with legitimate companies that want to do the right thing, legitimate companies. Big fines make headlines, but that is all they do. Press releases do not save lives. It is my understanding that Joe Ranazizi, a senior DEA official, has publicly accused we sponsors of the bill of, quote, supporting criminals, unquote. This offends me immensely. You know, before coming to Congress, I was a prosecutor and a United States attorney. I worked to put away violent felons and drug dealers. I ask that you commit to me today that you will look into this and get back to me on whether you think that statement is acceptable behavior. Such conduct is not acceptable, and it is unbecoming of the DEA, an agency that I have the utmost respect for. I'd like to hear from you on this in writing after this hearing. Finally, at our April 8 Judiciary Committee Oversight hearing, the Attorney General suggested he should meet with industry representatives and asked me to facilitate that. I've attempted to do that, but to date, no such meeting has taken place. I am disappointed that DOJ staff has not made this a priority, and I will be following up with a letter reminding the Attorney General of our exchange and his personal commitment. Chairman Goodlatte, Ranking Member Scott, thank you so much, and I yield back.
I thank the gentleman, and it's now my pleasure to recognize the ranking member of the subcommittee, the gentleman from Virginia, Mr. Scott, for his opening statement.
Thank you, Mr. Chairman. And first, I want to thank you for cooperatively working with the minority last week to develop bills on drug scheduling that we could all support. The original versions had several problematic provisions which you addressed without diluting the effectiveness of the legislation. I'm pleased to join you this morning in convening this oversight hearing on the Drug Enforcement Administration. I'd like to thank, I'd like to thank Administrator Lenhart for her years of dedicated service and for appearing before us today. I must also thank the thousands of dedicated DEA employees who enforce our laws every day, many of whom are putting their lives on the line to do so. The DEA is involved in drug enforcement activities all over the world. However, it is not clear that all of these activities are as effective or as important as others in stopping or reducing the scourge of drug use. In general, there are supply-side strategies and demand-side strategies to reduce drug use. Research indicates that demand reduction through prevention, education, and treatment can be much more effective than supply-side reduction through interdiction and law enforcement efforts. I'm hoping that the administrator will be able to shed some light on DEA's strategy with respect to prevention and intervention strategies and what works and what doesn't work. One of the big problems we have in this country with illegal drugs as well as illegal use of prescriptive drugs is that there is a huge demand for them. The history of the war on drugs shows us two things. First, that if there is a demand for the product, suppliers will find a way to provide it, no matter what cost or no matter what the sanctions. Second, the large amounts of drugs interdicted or captured annually represents only a small fraction of the drugs being trafficked. In fact, evidence suggests that the street price for some of the most dangerous drugs has actually gone down, while purity has gone up, and drug use has increased or stayed about the same. Therefore, the so-called war on drugs has had a negligible effect on the drug trade at the highest levels, but it has imprisoned legions of street-level dealers and users. Given that we've already spent billions of dollars without a significant impact, the question remains how much more would we have to spend in order to achieve significant results. And while drug use in all major categories among white Americans is as high or higher than the drug abuse among black and Hispanic Americans, the vast majority of those imprisoned for drug violations are black and Hispanic. The war on drugs has been waged almost exclusively in poor communities of color, even though the data shows that minorities are no more likely to use illegal drugs or commit crime. Black Americans make up 12% of the U.S. population, but almost 50% of those incarcerated for drug violations. Drug convictions alone make up about two-thirds of the increase in the federal population that's exploded over the last few years. The excessive and discriminatory sentencing penalties from drug convictions are driven mainly by mandatory minimums and also by consecutive counts and enhancements that are so draconian that many are serving life sentences or the equivalent in years, even for first-time low-level offenders. In fiscal year 2012, 60% of convicted drug defendants were convicted of offenses carrying a mandatory minimum penalty. These harsh penalties were intended to be used against kingpins and leaders in criminal syndicates. In reality, data from the U.S. Sentencing Commission shows that they're used against couriers, street-level dealers, and addicts. More than half of these defendants have the lowest criminal history category at the time of their conviction. Mandatory minimums are sound bites masquerading as crime policy. They sentence people before they're even charged or convicted based solely on the name of the crime. No consideration is given to how minor the role may be that one played or whether or not they're a first offender, a minor, or an abused woman under the control of a violent boyfriend. Even if the prosecutor, the judge, the defense counsel, and probation officer all agree that a mandatory minimum is too severe for a particular offender in a specific case, there is no choice. The judge's hands are tied, and the judge must impose the mandatory minimum as a matter of law. Now, all the research we have shows that mandatory minimums waste money, disrupt rational sentencing considerations, discriminate against minorities, and often require judges to impose sentences that simply violate common sense when compared to traditional proportional sentencing. As a result of the emotional appeal of the tough-on-crime policies, the United States has the dubious distinction of being the world's leader in incarceration, jailing 700 people per every 100,000 population. Most countries incarcerate about 100. The closest competitor is Russia at about 600. China locks up about 116 per 100,000, India about 36. Pew Research on the states estimates that any ratio over 350 per 100,000, for any ratio above that, the crime reduction value begins to diminish. Anything over 500 per 100,000 becomes counterproductive, messing up so many families, wasting so much money, having so many people with felony conviction records that you're actually adding to crime, not reducing crime. That's at 500 per 100,000. The United States average is over 700. And when we look at the lockup rate in the minority community, it's even worse. 10 states lock up African Americans at the rate of approximately 4,000 per 100,000. The rates of incarceration we have in this country, and looking at crime and simply suggesting that the main problem we have is that we're not locking up enough people, just doesn't meet with science, experience, or common sense. So one is left to wonder about the motivation to continue what amounts to a failed system in reducing drug trafficking and abuse when we consider how ineffective and costly the punitive supply reduction strategy has been. Reliance on incarceration is not free. When a drug dealer gets sentenced to 50 years at $30,000 a year, that amounts to over approximately $1.5 million. The money, the day after the drug dealer is sent away, his territory is taken over, so you really haven't done anything in reducing crime. But that same $1.5 million, if it had gone to the Boys and Girls Clubs, which held their annual congressional breakfast yesterday, could have been put to much better use. Maybe if we had just spent $500,000 locking up the guy and had $1 million for the Boys and Girls Club, we could have put hundreds of young people on the right track and kept them on the right track rather than the excessive incarceration for just one person. Those are some of the things that I hope we discuss today, Mr. Chairman, and I yield back the balance of my time.
I very much thank the gentleman for his comments, and I'm now pleased to recognize the chairman of the the ranking member of the full committee, the gentleman from Michigan, the former chairman of the committee, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte and Ranking Member Scott, and welcome Administrator Lynn Hart. Pleasure to have you here. The Drug Enforcement Administration is tasked with enforcing the most critical failing, in my mind, of our nation's criminal justice system, namely the war on drugs. And I want to discuss two things. First and foremost, the war on drugs has disproportionately impacted communities of color. And second, federalizing street crime undermines constitutional principles of limiting government prosecution to charges that cannot or should not be brought in state courts. To begin with, the collateral damage of the war on drugs has disproportionately harmed minorities, obviously. Admittedly, discrimination has permeated our nation's history since its founding. The Constitution itself devalued slaves or former slaves as 3/5 of a man. Through the Civil War, and though the Civil War was fought to abolish slavery, Jim Crow in its wake codified disparate treatment as the supreme law of the land. So we've been wrestling with this for quite a while, historically. While it has been 60 years since Brown versus the Board of Education struck down the abhorrent doctrine of separate but equal, and 50 years since the March on Washington and the passage of the Civil Rights Act, the casualties of our war on drugs continues to be separate and unequal. The malignant vestiges of racism, unconscious or not, lurk within our federal criminal justice system. Criminal justice and drug enforcement are meted out by human beings with real human failings, including bias and self-interest. Not all of them, but some of them. The statistics tell the story of the racially disproportionate impact of our federal drug laws and policies have had. Our country has spent over $2.5 trillion on the war on drugs. Our federal prison system is currently at 132% over capacity. Half of all federal prisoners are drug offenders. In 2013, blacks and Hispanics comprised almost 75% of all federal drug offenders. Currently, almost 40% of all federal prisoners are black, and 35% are Hispanic. Blacks are arrested for drug offenses at rates 2 to 5 times higher than whites. This is despite the fact that national data shows that people of all races use and traffic drugs at about the same rate. People of all races use and traffic drugs at about the same rate. Yet, African American and Hispanic men and women are sentenced and imprisoned for federal drug offenses at disproportionately high rates for virtually every kind of drug. While only 4% of federal crimes carry mandatory minimum sentences, 34% of those in federal prison are serving mandatory sentences, with blacks and Hispanics, of course, receiving sentences that are often years longer than whites in similar cases. Before we identify solutions, we must recognize how our laws and policies, along with systemic problems writ large in our federal system, interact with the Drug Enforcement Administration's practices in the war on drugs to contribute to this disparate impact. No longer does Jim Crow and overt racism rule the day, but rather euphemisms such as those, quote, who fit the profile, end quotation, who, quote, raise reasonable suspicion, end quotation, who reside in high crime areas where stop and frisk policies are the norm. Now, to be fair, bias creeps in at every branch of our federal government, from the initial decision of where and whom to monitor, which cases are accepted for prosecution, which defendants to charge with mandatory enhancements, and ultimately, which defendants receive upward or downward variant sentences. Particularly troubling to me, from a civil liberties perspective, are the DEA's civil asset forfeiture practices. The Drug Enforcement Administration, in conjunction with state authorities, can seize cash and property from men and women who are not convicted of, much less charged with a crime. This incentivizes state and local law enforcement agencies to engage in these seizures so as to apply the fruits of that bounty to their own budgets. The burden rests on the property owner to prove his innocence in a civil suit that costs frequently thousands of dollars in legal fees and months imprisonment. Much like we saw the DEA's Operation Pipeline in the 1990s, the overwhelming majority of those targeted for those traffic stops are black or Hispanic. Private contractors, such as Black Asphalt and Desert Snow, working with state and local authorities, have made it so driving while black or Hispanic means that one is presumed guilty absent any evidence other than an officer's hunch based on someone's appearance. Our reforms need to eliminate this bounty hunting incentive and disparate impact that it causes. To declare success in the war on drugs rather than continue policies that actually cause more harm than good, we must learn from the recent successes from our states and others around the globe. Our founding fathers recognized the value of delegating the general police power to the states and the important function that states serve as laboratories of innovation. We should permit these federalist principles to guide us in ensuring that federal jurisdiction is limited, complementing but not supplanting state jurisdiction. I conclude by pointing out that many states and countries have examined similar troubling disparities in their conviction and sentencing data. In response, they eliminated or reduced mandatory minimums for drug offenses or diverted those cases to specialized drug courts and emphasized treatment and reentry over incarceration. Their rewards have been not only billions in savings, but also reductions in their crime, recidivism, and addiction rates. While these reforms may sound counterintuitive, they offer common sense, proportional, and evidence-based responses to our current federal programs and penalties that are discriminatory, destructive, and ultimately counterproductive. Thus, we should cooperate with the states to develop policies to determine whether offenses should be prosecuted in the state or federal systems. And so accordingly, I look forward to Administrator Leonhardt's testimony about how the DEA and Congress can best address the concerns that I've identified. And I thank you, Mr. Chairman, and return any unused time.
The chair thanks the ranking member and assures him that there was not any unused time. And thanks him for an overly thorough exposition of the issues. But I know the issue is important to him, so I wanted to let him finish his.
Thank you.
It is now my pleasure to introduce today's witness. Michelle Lenart was unanimously confirmed as the administrator of the Drug Enforcement Administration in December of 2012, and she had been acting administrator since November of 2007 and served as the DEA's deputy administrator since 2004. Prior to that, she held several positions with the DEA's senior executive service. She served as special agent in charge of the DEA's Los Angeles Field Division and from 1998 through 2003, and special agent in charge of the DEA San Francisco Field Division in 1997 and 1998. As a career DEA special agent, Ms. Lenart held several key positions as she moved through the ranks of the DEA. In 1995, she was promoted to the position of assistant special agent in charge of the LA Field Division. She has had more than 30 years in law enforcement, beginning her career as a Baltimore City police officer after graduation from college in Minnesota with a Bachelor of Science in Criminal Justice in 1978. As is the custom of this committee, we'll begin by swearing in the witness, so if you'd please rise. Do you swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. Let the record reflect that the witness answered in the affirmative, and your entire written statement will be entered into the record, and we ask that you summarize your testimony in 5 minutes or less, and we have a timing light there on the table that will assist you in that information. And again, welcome to the committee.
Thank you. Chairman Goodlatte, Ranking Member Conyers, Ranking Member Scott, members of this subcommittee, thank you for the opportunity to testify before you this morning. This committee's support for the Drug Enforcement Administration has been enormously important to us. I welcome this opportunity to continue working with you and share with you our recent accomplishments and our challenges. DEA, in our unique capacity around the world, is responsible for enforcing the provisions of our domestic controlled substance and chemical diversion trafficking laws, and is honored to work closely with our state, local, federal, and international counterparts. In recent years, DEA's investigations resulted in the arrest and conviction of major international criminals, including Victor Bout, Mansour Alcazar, Haji Bashko, and even the former president of Guatemala, Alfonso Portillo. Most notably, DEA also supported the Mexican government's apprehension earlier this year of El Chapo Guzman, the head of the world's largest drug trafficking organization. These individuals highlight just a few of the successful cases we've aggressively pursued each and every day. Yet these law enforcement successes are only one part of the comprehensive strategy needed to address illicit drug use. A successful strategy must be comprehensive and include research, prevention, and treatment. There is no magic solution to the complex challenge of illicit drug use. This comprehensive strategic approach has been successful. According to an analysis by the Substance Abuse and Mental Health Services Administration, illicit drug use rates are lower by approximately 1/3 compared to 30 years ago. And since 2006, we've seen significant decreases in the number of past month users of cocaine. This does not mean that we aren't facing real and significant challenges. Years of overprescribing prescription painkillers, combined with decreased perceptions of risk, have created millions of new addicts. DEA has responded not just with enforcement actions, but also pushed to reschedule hydrocodone, a potent and addictive opioid. It is still readily available for legitimate use, but it is now subject to additional tracking, prescribing, and storage restrictions, which will minimize the potential for diversion. In addition, we have just released the final rule governing drug disposal, and this rule expands the public's options to safely and responsibly dispose of their unused and unwanted controlled substance prescription medications, and will make DEA's semi-annual take-back days unnecessary. While we have seen some progress to our counter-prescription drug abuse, we are beginning to see an increase in the trafficking of one of the more traditional drugs of abuse, heroin. After years of declining use, the availability and abuse of heroin is now increasing, especially among younger Americans. In response, DEA is systematically targeting high-level heroin suppliers in partnership with state and local law enforcement authorities, and has seen a steady increase in the heroin-related enforcement efforts nationwide. Marijuana abuse is another great concern for DEA, particularly because of changing public attitudes on its use. As you're aware, the administration opposes marijuana legalization. Approximately 19.8 million Americans have used marijuana in the past month, more than any other illicit drug. And this includes nearly 1 out of every 15 American high school seniors who are now nearly daily marijuana users. Consistent with the administration's comprehensive approach to the issue, DEA also supports scientific research efforts and ensures that there is sufficient marijuana availability for research purposes through a robust process of providing Schedule I research registrations to qualified researchers. In fact, DEA has never denied a registration for a bona fide marijuana-related research application. Looking forward, DEA will continue to build on the progress that we've made, and with our state and local partners, we will continue to target traffickers who operate in or whose drugs enter into our country. These investigations complement and support our international partnerships where we target the most violent and prolific drug trafficking organizations in the world. And it's clear to me as a career special agent and as DEA's administrator that not only is our mission an essential element to our national drug control strategy and to our nation's health, but also to the security of our country and our interests abroad. Thank you for your partnership, and I look forward to continuing to work with this committee and Congress on these important issues. I look forward to answering your questions.
Thank you very much for your testimony. I'll begin the questioning. Is marijuana possession, use, or distribution medically or otherwise legal under federal law?
Under federal law, any growing, cultivation, distribution, transportation, importation of marijuana is against federal law.
Despite the fact that this administration's current narrative in support of its position on sentencing reform relies on the supposition that too many low-level, nonviolent drug offenders are being investigated, prosecuted, and incarcerated federally, the Justice Department's own memo from last August providing guidance to federal prosecutors stated that the Department of Justice has not historically devoted resources to prosecuting individuals whose conduct is limited to possession of small amounts of marijuana for personal use on private property. Is this statement consistent with current and past DEA enforcement priorities?
DEA has never targeted drug users of any kind, especially marijuana users. We go after those that are trafficking, those that are members of organizations and cartels, those that are gang members that are supplying our communities. We don't target users, we don't target patients. We go after crime, we go after the drug traffickers.
In fact, in contrast to what this administration would have us believe, the federal prison system is not littered with scores of drug users ripped out of their bedrooms by DEA tactical teams for smoking marijuana. Is that correct?
That's correct.
The reality is that those targeted for sentencing relief by this administration are only those whose conduct, that is, trafficking large quantities of controlled substances, would subject them to mandatory minimum sentences. You've stated previously that based upon your 33 years of law enforcement experience, you believe that mandatory minimum sentences play an important role in criminal investigations, and I understand that you may have been discouraged from publicly taking this view, but how would the removal of this important tool affect the DEA's ability to carry out its mission?
Well, let me say I do believe that mandatory minimums have been very effective in our work over these many years, and would hope that we can retain that tool. On the other hand, I am aware that there's a number of initiatives that are being supported by the Attorney General to look at the bigger problem of prison overcrowding and to look at the money, the budget, now so much of it going to the Bureau of Prisons and not going to different programs that could help with recidivism, drug treatment, and such in the prisons. So balancing those two things, yes, it's been an effective tool, and it's very important that, especially with the type of trafficker and the level of trafficker that DEA investigates and arrests and indicts, that these folks, these very dangerous criminals, these cartel members, these gang members, serve appropriate sentences.
And it has been an effective tool, and it is the law of the land, is it not, at this point in time?
Right now, yes.
So as you know, switching to another subject, earlier this year, the House approved 2 amendments to the Commerce, Justice, State Appropriations Bill, Science Appropriations Bill regarding industrial hemp. These amendments were largely in response to litigation between the DEA and the state of Kentucky over the seizure of a large number of hemp seeds. The amendments disallowed DEA from blocking the importation of hemp seeds and preventing the cultivation of industrial hemp in states where it is legal. If DEA does not find ways to improve the process for approving the importation of hemp or hemp seeds for legitimate research, it will continue to see the courts and Congress stepping in. What are your comments? What is being done to improve that situation?
Well, DEA is looking at the Farm Bill and harmonizing it with the Controlled Substances Act, and actually has worked with several states to ensure that what the provisions of the Farm Bill, which allow institutions of higher education and state agriculture departments to grow industrial hemp for research purposes. We've been helping with them, like we offered to help Kentucky.
I expect, though, that this is the beginning of a process in which we're going to see the commercial production of industrial hemp, which is a historic product and a product that is abundant in legitimate uses for it, but it has posed a problem in terms of DEA enforcement because it's sometimes difficult to distinguish it from marijuana. So what are the ongoing efforts to improve the ability of the DEA to set up a system where you can distinguish between the two so that this potential industry can continue to grow but not hamper the ability of the DEA to enforce the law?
We can get there by working with the states. In this particular case with Kentucky, they did not obtain the right registration or permit to import seeds, and we have worked with other states now to help them get the proper registration. By using the process, which is importing the seeds with an import registration, and by DEA working with these agricultural departments and with these institutions of higher education, we then at DEA will have an idea of where the hemp is grown, but it does pose a very significant problem for not even so much DEA, but really our state and local partners, in that you cannot distinguish.
Well, let me reclaim my time because it's expired, and I just want to say that as this grows, literally and figuratively, this is an industry that's going to grow, and you're going to not just have state departments of agriculture and research facilities at universities involved, but you're going to have lots and lots, maybe thousands and thousands of just average American farmers growing this crop. The DEA is going to have to make adjustments, and they're going to have to be aggressive about finding ways to more easily distinguish between what's going to be legal and what's going to be illegal. My time's expired. I now am pleased to recognize the gentleman from Virginia, Mr. Scott, for his questions.
Thank you, Mr. Chairman. Ms. Lenhart, there are a lot of studies that have concluded that mandatory minimums disrupt rational sentencing strategies. They waste the taxpayers' money. They discriminate against minorities and frequently require judges to impose sentences that violate common sense. You've indicated that many times the mandatory minimums are appropriate, but that's, of course, not the problem, because you don't need a mandatory minimum to impose an appropriate sentence. Problem is it gets imposed on those for whom it is not appropriate. Are you suggesting that sentences, the mandatory minimums, do not inflict inappropriate punishment on anyone?
I'm saying that, when asked the question, have these been important tools, they have been for any of us in drug law enforcement. The decisions on what's an appropriate sentence for what crime is something that Congress takes up. And as long as there are sentences that fit the crime, sentences that ensure that the kingpins, the major traffickers, and those that are causing the violence in our communities are serving consistent sentences, then that will assist us in doing our drug law enforcement.
Are you suggesting that they're not inflicted on people for whom there's no rational basis, like girlfriends of kingpins getting decades of prison time? Are you suggesting it's never totally inappropriate, totally violative of common sense?
I would say it depends on what their role was in the organization and what, were they violent traffickers? What were they trafficking?
The
What were the
president, the
quantities?
president's clemency program suggests that that the Attorney General will consider clemency for those who have already served 10 years, are low-level, nonviolent, essentially first offenders. Doesn't it raise a question, what is a low-level, nonviolent first offender doing with 10 years to begin with?
Again, DEA targets the baddest of the bad, the worst of the worst, the highest level trafficker.
That's
And
right, and they get long sentences, and that's appropriate. What about those for whom the sentence, are you suggesting that you don't inflict that on people for whom the sentence violates common sense?
I think
That's what the mandatory minimum requires a judge to do.
I think it's important that there's discretion by the prosecutor on what they charge, and then it's up to the judge to sentence.
Wrong. That's what a mandatory minimum requires a judge to impose, a sentence that violates common sense.
And there are safety valves, protections. There are a number of things in sentencing that can be used. But
10
I also
years, 10 years
support.
for a nonviolent, low-level first offender. That makes sense to you?
I'm sorry.
10 years, more than 10 years, because you don't get clemency until you've already served 10, and you've got so much more time to serve that you need clemency. Low-level, nonviolent first offender.
If that first offender was trafficking large quantities of heroin that were then spread across the community, I think that that's an appropriate sentence. And those are the.
And suppose he's just a low-level, somebody on the tangent, girlfriend taking a message. Are you suggesting that makes any sense at all?
I would have to know the circumstances. I just know
All
that
circumstances, because it's a mandatory minimum.
if a mandatory minimum is appropriate for that crime, that's determined by the prosecutor who charges the crime. And these are decisions that aren't taken into account when DEA investigates an organization.
Well, I mean, well, yeah, but we're making policy, and you suggested that there's some value to these mandatory minimums, and yeah, sometimes the sentence is appropriate. Many times, it's just stupid. That's what the mandatory minimum requires the judge to do, and that's why we're trying to get rid of them. But if people say, well, you know, they got value, it's kind of hard to make policy.
The Attorney General is putting forward a number of initiatives under his Smart on Crime initiative, and one has to do with the sentencing and the clemency that you're speaking of. And he's assured us that the traffickers that we go after, the traffickers that are the most violent and are leaders of gangs and cartel leaders, and the most violent of those traffickers trafficking on our streets, will not fall under that and will serve their appropriate sentences.
That's right, and those that do fall under that get stuck with the mandatory minimum anyway. That's the insanity of the mandatory minimum, whether it makes sense or not. I yield back.
Thank the gentleman from Virginia. Madam Administrator, I want to start by recalling for you, I got a phone call from an old colleague of mine, a guy named Beatty Ashmore, yesterday, told us that a DA agent that we work with named Randy Smith was maybe contemplating retirement, and I couldn't imagine that. Seemed like last week that Randy was just starting, but I want to call a list of names to you, and if you would be gracious enough, if you ever run into any of these folks, to just, you don't have to write them down, I'll give them to you, but you know, Mark Knight and Tony Duarte and Steve Russell and Bill Lunsford and Mark Pogue and Randy Smith and Kevin McLaughlin and Frank Smith are just some of the DEA agents that I had the pleasure of working with, and they represented your agency so well and so professionally, and it's such a difficult, hard, oftentimes thankless job. So if you ever have a chance to tell any of them that they are appreciated, I'd be grateful to you for that. I want to touch on a couple of things real quickly. I want to finish up. There's no one in Congress that I have more personal respect for than Bobby Scott. So I want to finish up by talking to you about mandatory minimums a little bit. But I've got, speaking of DEA, we prosecuted 2 physicians way back in the day for prescribing or dispensing controlled substances outside the course of a legitimate medical practice. I don't hear from doctors much anymore. I do from time to time, not in a complaining way, but I do from time to time hear from drug companies. And it just strikes me that the best way to get at folks who are abusing legal prescription drugs is to target the physicians. That's who's writing the prescription. And it's been done before. There were DA diversion agents. I assume there may still be, but even if there aren't diversion agents, it's not that hard to go into a physician's office without establishing a doctor-patient relationship. One fact pattern, there was a prescription written on a cocktail napkin at a bar. Even I could win that case at trial. So I just want to ask you to be mindful. I'm not going to call the name of the drug company, but it is one of the most well-respected companies in my entire district. And I just don't want any of the drug companies. And in the interest of full disclosure, my father's a physician. I grew up around doctors and pharmacists. I have incredible respect for them. I don't want the message to be sent that we view them in the same light that we view a doctor who's writing a prescription on a cocktail napkin for somebody he met at a bar. If there are reporting requirements, I'm all for working with the drug companies. I just don't want them to feel like, because my understanding is if you get a prescription, the pharmacist has a duty to fill the prescription unless he or she has some reason to suspect it. And you got a drug company even further removed that's just getting a request for X number of drugs so this pharmacist can fill that prescription. So if you would look into that and just make sure that we are including the drug companies so they feel like they are part of the solution rather than surrogates for doctors who are writing prescriptions they should not be writing.
I can assure you that we actually view distributors and manufacturers, doctors, pharmacists, the whole gamut, everyone involved in this closed system of distribution as partners in trying to resolve and tamp down on this exploding prescription drug problem. And we've had a number of initiatives where we're working with companies so that they can better understand what those signals are, what those red flags are on what a suspicious order would be. And many times, working with them, they are actually able to then put out warnings or cautions to the people they're distributing to that it is suspicious and that they're not going to fill orders. So those companies are very important to helping us in our fight to prevent diversion. We don't look at them as the enemy. We don't look at them as drug.
I'm sure you don't, and I know that you will do a remarkable job of communicating to them that they are partners as opposed to targets. In the few seconds I have remaining, I do not recall it being a crime to be the girlfriend of a drug dealer. Did that become a crime since I left the U.S. Attorney's Office?
That's why I said I needed to know what the circumstances were. What drugs were they distributing?
Well, there wouldn't be anybody serving federal prison time for simply being the girlfriend or boyfriend of a drug dealer. Nor is there anyone serving federal prison time for being the boyfriend or girlfriend of a drug dealer and accepting a telephone call. You have to be convicted of conspiracy. You have to be convicted of a RICO activity. You have to be convicted of possession with intent to distribute a controlled substance. I mean, there's nobody serving time for simply being the girlfriend or boyfriend of a drug dealer, much less serving a mandatory minimum. Agreed?
Correct.
All right. Why do you think, in your judgment, why do we have mandatory minimums? What was the impetus behind Congress deciding we should have mandatory minimums?
I came on DEA as an agent after being a police officer in 1979. Hired by DEA in 1980, went through the academy, and at the time, I can tell you that when we did our cases, the criminal histories we received for the people that we were investigating would blow your mind. It was a revolving door in and out of the system. I also can tell you that working cases in the Midwest, I was more than often I was the undercover agent. It was also surprising to see how, depending on where you were in the country, the different kinds of sentences that people would receive for the very same crime. So to see the mandatory minimums kick in, you started to see more consistency. You also started to see that those that have been routine, criminals in and out of the system and increasing their involvement in drug trafficking were finally stopped by the types of sentences that they were sentenced to.
Well, I am way over time, and I'm going to, yes, sir.
Unanimous consent request.
Yes, sir.
Mr. Chairman, I ask unanimous consent to insert into the record case histories of girlfriends who have gotten caught up in taking message. If we take a message, you're part of the conspiracy, and you are in fact sentenced based on the weight of the drugs that the boyfriend is dealing, which will result in decades of time for people who have no meaningful role in the conspiracy. And I'd like unanimous consent to insert those case histories into the record.
Without objection, and I am grossly over time, and I'm going to give all of my colleagues on the other side at least as much time as I took over. And I'm going to say again, there's no one in Congress that I have more respect for than the gentleman from Virginia, who has been a champion on this issue for the entire time I have been in Congress. And if he says such cases exist, I believe him, period. I would encourage them to pursue post-conviction relief because they had a lousy criminal defense attorney. If all they did was take a telephone call and the relevant conduct racked up and accumulated such that they reached a mandatory minimum. And before I recognize the next colleague, Madam Administrator, there are currently ways to get around mandatory minimums. There's Rule 35, there's the safety valve. I assume there's still 5K 1.1s, although the stated guidelines have changed. So the notion that there's no way to get around a mandatory minimum even today is not accurate, right?
That's correct.
All right, gentleman from Michigan, Mr. Conyers.
Thank you, Mr. Chairman. You've startled me today with some of your testimony, Madam Administrator, and I would like to find out if you're familiar with data from over 17 states that demonstrates eliminating or reducing mandatory minimums has not statistically affected rates of cooperation or pleas.
I'm not familiar with that data.
Well, I'll put something in the record and give you some information on it. Administrator Leonhardt, it's fair to say, based on Sentencing Commission data, that the majority of drug convictions are of couriers, mules, drivers, low-level dealers. And so I ask if you agree that existing state laws cover that conduct as well.
That's correct.
Sure. Okay. Would you also agree that kingpins and leaders do not, by any stretch of the imagination, comprise the bulk of the convictions, drug convictions in this area?
When DEA pursues drug investigations, the goal is to disrupt and dismantle an entire organization. So yes, there's leaders, heads of organizations, lieutenants at the top, but there's also all those facilitators that help the organization in their crimes.
Yeah, that's who gets caught, the little guys, the mules and drivers, low-level dealers. But I'm talking about an examination which I will be doing after this hearing, that kingpins, the people at the top very seldom get convicted. And that's the issue that I'm raising with you for discussion at this time.
Ranking member, I would have to tell you that DEA has been very successful in taking down the leadership of organizations. And just look at our Kingpin program. Of all of the Kingpins identified since 2002, DEA has indicted over 75% of them. Most of them don't even operate on our shores, and yet we've been able to arrest over 55% of them, and we've extradited to the United States over 33% of them. So we are investigating them, we are indicting them, we're arresting them, and we're actually extraditing them to the United States. They are prosecuted and they serve long sentences.
Well, what I'm suggesting is that the leaders and kingpins do not comprise anywhere near the bulk of the convictions, and I'd like to follow this up with you or your staff in terms of a study of the statements that you've just made in that regard. Let me turn now to this final question. The Drug Administration, the Drug Enforcement Administration, is a component of the Department of Justice. So would you agree that its official position supports the Smarter Sentencing Act, which reduces mandatory minimums?
We support the Attorney General's initiatives under Smart on Crime.
Mm-hmm. And that includes the reduction of mandatory minimums, which is part of the Smarter Sentencing Act.
We support the initiatives forwarded by the Attorney General with his assurances that these will not impact the traffickers that the DEA spends the majority of our time going after, the kingpins, the violent traffickers, the gang leaders, and such.
Well, I'm going to have to compare that with some other comments that you've made, because it seems to me that there is a certain contradiction between your response to this question and other comments that you've made here today before the committee. And well, here's the Huffington Post. Obama's DEA chief refuses to support drug sentencing reforms. I don't know how accurate it is, and I don't know, dated from a few months ago, but that's the part of the contradiction that bothers me between some of the statements and comments that you've made here today. But we'll be following this much more carefully now that you've had a chance to come before us. Thank you, Mr. Chairman. I yield back.
Thank the gentleman from Michigan. The chair will now recognize the gentleman from Puerto Rico, Mr. Pierre-Louis.
Thank you, Chairman. Administrator, thank you for appearing before the subcommittee. You and I met in February 2012 to discuss drug trafficking and related violence in Puerto Rico. In June of that year, we spoke again about this issue when you testified before this subcommittee. Finally, we spoke by phone in April of 2013. I have also spoken on multiple occasions with Vito Guarino, the special agent in charge of the DEA's Caribbean Division based in Puerto Rico. As you know, I have placed great pressure on DOJ and DHS to increase the level of resources dedicated to Puerto Rico, which is a major transshipment point for drugs destined for the U.S. mainland. The need for federal law enforcement agencies to enhance their efforts in Puerto Rico is particularly important because, according to DEA, drug traffickers are increasingly using the Caribbean region to transport cocaine to the States. In late 2013, DEA officials were quoted as saying that the percentage of U.S.-bound cocaine trafficked through the Caribbean had risen to 14%, which was double the percentage in 2012. Puerto Rico is an attractive jurisdiction for drug traffickers because the island is an American jurisdiction within the U.S. Customs Zone. The role of federal law enforcement agencies is simple: to make Puerto Rico a less appealing operational environment for drug traffickers. That requires the federal government to develop a comprehensive strategy and to allocate the resources required to implement that strategy. In terms of strategy, Congress has required ONDCP to prepare a counter-narcotics strategy for the Caribbean border, with an emphasis on Puerto Rico. In terms of resources, prior to 2012, I criticized the federal government for not doing enough. Since 2012, however, I have seen some real progress. Make no mistake, the effect of these enhanced efforts can be measured in lives saved. Nevertheless, Puerto Rico's murder rate is still the highest in the country, averaging nearly 2 homicides a day. While I know DOJ is doing great work in Puerto Rico, I have candidly told Attorney General Holder and FBI Director Comey that the department must do more. This is not just my personal opinion. In both the 2013 and 2014 CJS appropriations bills, Congress directed the Attorney General to assess whether there are sufficient DOJ personnel and resources assigned to Puerto Rico, to identify the additional resources that may be necessary, and to brief Congress on the findings. In light of this background that I'm giving you, I have 2 questions, and depending on time, I might follow up on the sentencing guidelines issue. First, what specific steps, including any new initiatives, is DEA undertaking to combat drug-related violence in Puerto Rico? And second, I understand that the DEA has incentives in place to encourage agents to relocate to Puerto Rico and to remain there beyond their initial period of service. However, I have learned from agents assigned to the Caribbean Division that there appear to be inconsistencies in how agents have been treated under this incentive program. I am concerned about the possible effect this could have on mission performance. So I would like you to give me your views on this issue. I said, since I see time kind of expiring on me, on this sentencing guidelines issue, let's set the record straight. You're not the one setting policy on this on the administration's handling of sentencing guidelines, correct?
That's correct.
So your views are just your personal views. Is that correct?
My agency views, my views as a law enforcement officer and as a DEA special agent, but these issues are presented by the Department of Justice, and we support the Attorney General in his initiatives.
And until Congress revises or changes the sentencing guidelines, your commitment is to go after major drug traffickers as opposed to low-level drug offenders. Is that correct?
That's correct, and that's always been DEA's mission.
Even before your tenure? Are
It's
you
always
sure of
been-
that?
It's always been DEA's mission to go after organizations, major drug traffickers, and we even made a change in 2002. We started our own in 2002, Smart on Crime initiative, and that was priority targeting and the kingpin list.
I'll go back to Puerto Rico, but frankly, there's an issue here because the statistics do not seem to, they're not consistent with what you're claiming has been DEA positions for so long. You know, there's a problem here because the statistics do not confirm that. But at least you're saying you're not going to be going after low-level drug users. Is that correct? Or drug offenders?
No, we go after organizations that are causing the most violence in a community, are are responsible for the majority of the supply in a community, are the most violent, and those that are the heads of organizations.
Thank you. Mr. Chairman, thank you for your indulgence. If you could allow the witness to address my questions on Puerto Rico, the ones that were specific about Puerto Rico, I would really appreciate it.
Absolutely.
Just to allow her to answer.
Absolutely, yes, sir.
Thank you.
On your first question about new initiatives, we've seen an increase in productivity by our office in Puerto Rico. In fact, I was talking to the special agent in charge, and we're up about 20% in major investigations. We're up over 80% in the number of Title III intercepts we're doing of these major traffickers. And more importantly, I have, over the past several years, increased the staffing in Puerto Rico. What really hurt was during sequestration and the tough budget years, we were not able to hire. And our first full graduation class graduated last week, or 10 days ago. And out of that class, the 45, our first chance to put new agents in Puerto Rico, those 45 graduates, 3 of those graduates are headed to Puerto Rico. We prioritized ahead of the southwest border and ahead of our major offices that have had lots of vacancies, because I'm about 600 agents down. We prioritize Puerto Rico so that they can get there and assist with the enforcement progress that we've seen in Puerto Rico. On the other, on incentives, when we've met, you know, I've told you I'm committed to do what we can to help Puerto Rico, and that's why I traveled to Puerto Rico. One of the things I heard was that there was a new incentive that the Department of Justice was had approved for our components, and that was to give extended assignment incentives to agents who had been transferred to Puerto Rico, and after a number of years, an incentive to stay there, start paying those. I approved that policy, and we started paying them. When we started paying them, some of the people who were getting another kind of bonus were paid incorrectly, and we're still correcting that. But I had approved the extended assignment incentives, and those agents have been getting paid. So I'd be glad to come and talk to you about the specifics, but know that you have a brand new incentive to, it won't get the agent to Puerto Rico, but it will help the agent that's assigned to Puerto Rico decide to continue a tour longer than the standard 3, 4, 5 years in Puerto Rico. I think that will help you be able to maintain very good talent in Puerto Rico.
Thank you.
Thank the gentleman from Puerto Rico, and the chair will now recognize the gentleman from Utah, Mr. Chaffetz.
I thank the gentleman from South Carolina and the chairman. I do appreciate you being here. I want to thank the men and women throughout your agency. Do a very difficult job. I've seen them in action. I enjoy going out on ride-alongs to see how they do things firsthand, and they're professional, and they do a very difficult job. But I just want them to also know how much we care and appreciate what they do and how they do it. And not thanked enough for the difficult job that they have ahead of them, and to their spouses who and loved ones who worry about when they're out there doing their jobs. I just want to say thank you. I want to talk about prescription drugs for a moment. There's some concern that perhaps in the prescription drug process that there's maybe not as much involvement with those along of the chain there, that your lack of interaction and communication and input from those that are dealing with these controlled substances, whether they be the drugstores themselves, those that are or writing the prescriptions, and the consumers, what is it that you're doing to make sure that you understand that process, what they're going through, and that they're included as you move along to set up the rules and boundaries? And the second part of that is, what sort of recourse do they have if you have some new rule, and are they allowed an opportunity to have some sort of recourse and interaction with you?
Thank you for the question. You know, you weren't here when I said it earlier that we consider everyone in the chain, that closed chain of distribution. We consider everyone partners, and we all have to do our part, and that's what will stop diversion. So we have, over the past several years, implemented a number of ways to improve communication. And I can tell you more recently, we have done some things to improve that communication.
And I guess, not to cut you off here, I'm sure there is a much more elaborate process, and there are things that I'm not aware of. I'd like to become aware of them. Is that something you could share with this committee or with my office? I would sincerely appreciate it.
Yes.
Because I do think there are people who are wondering what is the formal process for recourse or for when you're going through. And one of the things I wanted to, as we wrap up here, the disposing of prescription drugs. For instance, that was put into law that you were to implement that. It took years for you to come up with a process that to do this. It seems rather simple to me. I'm sure there are a number of gyrations and things you have to go through in order to get it just right. It took an exceptionally long period of time. Nevertheless, I'm glad that it's there. But it was stone silence on figuring out where you were at, how long it would take in order to get there. In general, are you going to be able to go to a pharmacist or a pharmacy or a drugstore and be able to dispose of prescription drugs that you didn't consume or didn't need? Is that something you're going to be able to readily do?
The new disposal regulations that we put out are going to allow Americans on a 24/7 basis a way to dispose of their drugs. And one of the things they'll be able to do is participating pharmacies will have either receptacles. Some of them will also have mail-back programs that will be available. Citizens can also go to their participating hospitals and clinics. And those that have a pharmacy in-house are allowed the same rules and will be able to have receptacles or mail-back programs. We also thought it was very important to preserve the ability to have community groups partner with law enforcement to have periodic take-back programs. So we've made sure that we've covered the whole gamut from pharmacies, hospitals, clinics, police departments, and community groups, and included a way for people within the VA to do it as well, and long-term care facilities.
Well, I look forward to following up with you on that. Is keen interest to people in my district and some of the hospitals and pharmacists in our district, and I look forward to following up with you on that program. And yield back.
Thank the gentleman from Utah. The chair will now recognize the gentlewoman from California, Ms. Chu.
Thank you, Chair. Actually, I wanted to follow up on this issue of prescription drugs because I've been contacted by my pharmacies who are very concerned about this as well. It's come to my attention that there have been cases where individuals who suffer chronic pain have faced challenges accessing properly prescribed pain medication. And I'm concerned that some pain sufferers are not able to gain such access. For example, take the case of Karen Westover of Newport Richey, Florida, who had one kneecap removed and suffers from fibromyalgia. She's had pharmacies deny her prescriptions many times over the past couple of years. On one occasion, Walgreens initially refused to fill her prescription because Westover didn't live within 5 miles of the store. And when it was confirmed by the pharmacist that she lived within 3 miles of the store, Westover was still unable to get her prescription filled. Now, I understand that pharmacies have been tightening their rules after the DEA has imposed record fines on pharmacies based on allegations that they weren't scrutinizing questionable prescriptions. But I do believe that a careful balance has to be struck between attacking the prescription drug abuse epidemic while not preventing legitimate patients from accessing pain medication. And it's for this reason that I'm proud to be an original co-sponsor of H.R. 47009, Ensuring Patient Access and Effective Drug Enforcement Act, which was introduced by another member of this committee, Tom Marino, and passed by the House in July. I believe that this bill would foster communication and transparency between industry and the DEA. So, Ms. Leonhardt, could you comment on how the bill could help in ensuring that patients with legitimate prescriptions for pain are not being denied their prescriptions at pharmacies? And could you expand on what the DEA is doing to ensure access for these patients?
Well, I thank you for your question because this balance is very important to us. And, you know, we have a responsibility to make sure that patients that need the medication have it available, and at the same time make sure that those that are participating in diversion are investigated by us, whether they're the pharmacy, the doctor, the retail distributor, or the wholesaler. I too get calls and letters from people concerned about not being able to get their medications, and we have followed up on a number of them. And one of the things that we have found is that often when someone has gone to fill a prescription, the pharmacist will say, "I'm out of my DEA quota." There is no DEA quota to a pharmacy. And what has happened is because of the explosion of, you know, the prescription drug problem, you have a number of people, drug seekers, with invalid prescriptions going and getting their prescriptions filled. And that is a reason people with legitimate needs, when they go to try to get it, they can't get their prescriptions. So we are working very closely with the pharmacies. In fact, we did a training last week in Phoenix. We call them physician or pharmacist drug awareness conferences. And we've done them in over 20 locations, and we'll continue to do that. And what we're finding out is that by sitting down together and going through what, you know, we go through what the drug problem is, we go through all the methods of diversion, we go through what the corresponding responsibility is. We feel that in those locations where we've done that, that we walk away feeling that the pharmacist is better aware of what their responsibilities are. And we're hoping that a lot of the efforts we've put in place, such as the pill mills that were shut down in Florida, that now really is part of the reason that Florida has a 50% lower overdose rate currently, that these different things we've put in place over the last couple of years will ensure and help make sure that the patients who have a valid prescription will be able to get their medications. Even in the enforcement actions we take that into consideration. If we take an action on one pharmacy, what is that going to do to the patients who depend on that pharmacy? We take that all into consideration, and it's not lost on us, the importance of making sure that the balance is right.
Thank you.
Thank the gentlelady from California. The chair will now recognize the gentleman from Virginia for any closing remarks he thinks are appropriate.
Thank you, Mr. Chairman. Mr. Chairman, as I indicated, I would like to introduce for the record, we have right now 2 case histories. One points out that a girlfriend, Stephanie George, was sentenced based on 500 grams of crack that her boyfriend had, and she was given a life sentence. She did have a prior record, but because she had let him leave his crack there, she was part of the conspiracy, and the weight of the conspiracy and what the sentencing she was based on was the 500 grams. And then I'd mentioned Kimber Smith, and this is an outline of her case. Her boyfriend was dealing crack. She ended up with 24 and a half years. Both of these were subject to presidential commutations. But there are, as I indicated, hundreds, possibly thousands of people in jail today on low-level nonviolent offenses for which their sentences of over 10 years must have been a product of mandatory minimums, and like these in the record, and unanimous consent to introduce others as they come in.
Without objection. Well, while my friend from Virginia was talking, I couldn't help but think, Madam Administrator, about the awesome power that prosecutors and law enforcement agents and officers have that play an incredibly important role in our society, but the awesome power to accuse and to then prosecute and ultimately sentence should be sobering for all of us. But it's also a nice opportunity, in conclusion, for me to, again, thank you and women and men of DEA who do an incredibly difficult job. And you don't have to see it up front. Guys like Marino and others have seen it up front, but you don't have to see it up front to appreciate how difficult it is to be in law enforcement. So if you could just let the folks know that. And in conclusion, I just made a couple little notes. If you do have an opportunity to sit down with Congressman Marino, I would encourage you to do it. Tommy has a very compelling life narrative, one that I have the pleasure of sitting beside him. So just the way that he came to become a prosecutor, working in the family business, U.S. attorney, state prosecutor, I know that y'all would have a whole lot more in common than you would have differences. So if you have an opportunity to sit down with Tommy, I would appreciate that. Anything you can do to work with drug companies so that they view themselves as partners as opposed to targets, I would be grateful for, and continue to express your opinion with respect to matters related to sentencing reform and the virtues of mandatory minimums or the shortcomings as you see them. But I keep coming back to the biggest point of distinction between the safety valve, or Rule 35 and 5K 1.1, and what the Attorney General has proposed is cooperation with law enforcement. And I just don't think it's asking too much of those that want to benefit from a reduction in sentencing that they cooperate with law enforcement. I think that's a legitimate expectation. So, yes, sir.
As I indicated, additional case studies have come in. One is Bonnie Totoro, who was in the next room when her boyfriend sold undercover agency a lot of cocaine. She received a 15-year mandatory minimum. And Mandy Martison, who was also in essentially a sentence for her boyfriend's offenses, received a mandatory 15 years. And like these also entered into the record.
Without objection, and I will again say what I said earlier to my friend from Virginia. If either of those two defendants had somebody as capable as you defending them, they wouldn't be in prison at all, because mere presence at the scene of a crime is not a crime. But because I do respect the gentleman from Virginia, I'm going to read the cases, and because I told him I would. And again, it reminds us of the awesome power that law enforcement has, and judges and prosecutors, and they should be ministers of justice and not just try to rack up as many convictions as they can rack up. So with that, this concludes today's hearing. I want to thank our witness for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. And with that, thank you, Madam Administrator. This hearing is adjourned.